Good morning. Bon après-midi. Unusakut. I'm just waiting for everyone to join us slowly but surely. It's Nalini sitting in the boardroom with my colleagues Adele and James, who's our summer law student. I'll just give it another minute for folks to join us. Maybe Santana, can you tell me if this would be a good time for me to open up?
Yep, you're good to go.
Okay, wonderful. So nice to see so many members joining us today and Friends of the Law Society. And this is a particular topic that is near and dear to me. And I wanted to thank, in particular, Craig Boyer, who's joining us today as one of our speakers, who stopped by our office and had coffee with me, and just talking about some of the challenges of a small community, and coming up with ideas and tools to support our membership as we sometimes go through challenging times, which impacts all of us, whether here at the Law Society or our members or clients that we work with. And Craig was kind enough to also reach out to Alberta Assists. And I'll let Mark Adler, who's the program director, talk a little bit more about Alberta Assists. But I really hope that this will be a CLE event with some takeaways and some insight for everyone to consider. So over to you, Rebecca. Rebecca Jaremko is our CLE program manager, and she usually takes the lead. But today I thought I would just share a few words with all of you and thank our speakers, Craig and Mark, for taking time from their schedule to join us today. So over to you, Rebecca.
Okay, great. Well, thanks so much, Nalini, and thanks so much for being here. So as Nalini has said, we are privileged today to have Craig Boyer and Mark Adler here, both of whom are from Alberta, but with some experience in Nunavut. So Craig is with Shores Jardine and Mark Adler is with Alberta Assist. And without further ado, I'd like to give them the time to talk.
Thank you very much, Rebecca. Thanks you, Nalini. Thank you for everyone for being here. I'm just going to speak for maybe 10 minutes or so before our guest of honor, Craig, speaks about this very important topic. So first, let's make sure the tech works. I've got a little presentation prepared, so I'm just going to share my screen here.
And Mark, I'm just going to jump in. Mark did send me his slides, so I was able to post Mark's slides on our website. If you go to the homepage of our Law Society webpage in today's CLE event, you'll be able to see Mark's presentation as well. So over to you, Mark.
Okay, great, wonderful. Thank you. Can you see? Thumbs up, you can see the slides? Perfect. Okay, so thanks everyone for joining today. We're very pleased that, let me see if I can advance my slides. There we go. Yeah, thank you everyone. Very grateful for this opportunity because this is a very important topic, especially for small bars like Nunavut. So we're very pleased that you asked us to be here today. So here's our short agenda. I'm just going to give you a little spiel about Alberta Lawyers Assist in case you weren't aware of who we are. And I'm going to give you a brief rundown on the current landscape of mental health and civility in the legal profession. Then we're going to hear from Craig and hopefully have some Q&A at the end, time permitting. So Assist, here's our vision. That top line is the key, is preventing stress from becoming distress. And that is it in a nutshell because it all goes, the vortex goes down from there. So Assist is here to prevent you from going down that spiral. And I've been down that road myself personally. That's why I'm working for Assist right now. So it's really important. We help everyone, lawyers, ARCLing students, law students, and their dependent families in Alberta and Nunavut through a partnership. So please keep that in mind. We're here for you. Just so you know, Assist has been 30 years now and counting. It's our anniversary right now. So completely free, 100% confidential, fully independent from the Alberta Law Society, from the Nunavut Law Society. We've helped thousands of people over the years. There's never been one incident on confidentiality. No personal information is ever shared with Law Society. It's the cornerstone of our existence is confidentiality. Okay, so please remember that. We have 4 pillars of support. Our most well-known is number 1, professional counseling. Well, we also offer peer support, which is what I manage that program, education and awareness, and community. Professional counseling, key details on here. There's 4 sessions per person per issue per year. So it may not seem like much, but per issue means that it can expand because an issue can be anything. All our psychologists that we have on contract are registered 10 years minimum. They're very knowledgeable about the legal profession, which is amazing because that's often not the case when you go to search for a counselor. And you just book by calling that number. And there's also 24/7 crisis counseling available, same number. Okay, and I'll put this on at the end as well. The other programs I mentioned, peer support, education awareness, community. So peer support is really effective. We have over 150 volunteers, highly experienced. And if you were to alert me if you're having a particular issue in some area, we most likely have a person that's been there, done that before, and you can have hot coffee with them and have get their insight and their experience. So it's very helpful and proven to be very popular. We also got all these other programs. 3 I want to really highlight because these can make an immediate impact in your life. Every Monday at noon, we have a Red Mug Coffee Circle where Craig often joins every week, and we have topics of interest ranging from job searching all the way up to stress and distress and how to cope and how to thrive in the legal profession. Mindfulness. I'm a huge proponent of mindfulness. It's Tuesday at noon. It's only 15 minutes. It's online. We have a highly trained international expert who's donated his time every week. And it really is the doorway to a calmer, more effective and more productive life in law. And I mean that with all sincerity. So I'll talk about maybe that a little bit more later. Yoga is also every Wednesday at noon. It's live streamed, so you can do it from your office. And please just email me if you want the links to any of those 3 amazing programs they run every week. Just to break the stigma here, since 2008, 1 in 3 Alberta lawyers and students have used our programs. Stigma is really not what you think. This is there was a groundbreaking study in Canada in 2022. And look at the wording in red here, mental health issues, a sign of weakness. So this means that only 6% of I think it was about 8,000 lawyers surveyed in Canada thought that was true. But if they asked them, do you think others think that is true? Over 50% thought that others would think so. So you see what's going on here. It's not what you think it is. Stigma is weakening, and we are doing our best to make sure that's the case, because the truth of the matter is to not see mental health on par with physical health is just scientifically incoherent, and it's really harmful. Mental health is physical health. They're connected. The mind and the body are not 2 things. That's been proven over and over again. So we're trying to raise awareness around mental health, that it is imperative that it's seen as important as physical health. Okay, and you are not alone in this. The reason I'm actually in this position is when I found out just how not alone I was in my suffering in law, I decided to try to dig into this and try to help and let others know. So asking for help is not a sign of weakness. It's actually the epitome of strength. Okay, so please make the call if you are suffering at all, or even if you're not sure. Here's our contact information. Okay. Now, just quickly into part 2, this is the current landscape, what's going on. In case you weren't aware, there is a mental health crisis. That's not my words. That's the Alberta Bar Association labeled it a crisis 10 years ago. So you may not be aware of this, but they've been studying this issue, why lawyers are so unhappy my research shows it goes back to the 40s when it was first discussed, as far back as I can go. It wasn't actually studied, though, in detail until about the 80s. So here we are in 1990. Lawyers were highest among 104 occupations. Fast forward to the 2000s, lawyers are still unhappy. This was Martin Seligman dug into it. And that time he invented positive psychology. So he's a very famous psychologist. Canada got involved finally in 2022 with its first comprehensive national study on wellness. So what did it find? Not good. Very high prevalence of distress and depression in law. Words like ring the alarm were used back then. Lawyers in all areas, all jurisdictions, significantly high levels of distress, depression, anxiety, burnout, suicide, ideation, on and on. Those in early years of practice experiencing the highest rates of distress across the board. So what we're actually seeing, very high chronic distress, and you'll see the word I've highlighted here, harassment, violence, incivility, and that's what we're here to discuss. But I wanted to give you the general background first. So really, lawyers are suffering about 2 to 3 times more than the general population across all multiple measures that you can measure it on. I won't go into this, we don't have enough time, but here are some of the stats you can look at in the 2022 study. If there's any articling students in the crowd, you'll notice that 72%, so over 7 out of 10 students are experiencing psychological distress after 12 months. And that's alarming. Burnout is 63%. My thesis is that doesn't start right on day one of articling. It starts in law school. That's why I teach a course on mental health in the legal profession to third years at U of C, trying to get in at the ground level there and see what's going on. So highest anxiety and depression, lawyers with disabilities, 50%, articling students next, females, LGBTQ2S. Okay. Incivility. This is a key component. It was also mentioned in detail in the study. 60% reported being frequently exposed to incivility at work over the past 5 years. And it was seen as a quote unquote key factor influencing mental health. So it contributes to psychological distress, burnout, and exhaustion. And they found it increased in line with billable hour targets, not surprisingly. And this was distressing. The most vulnerable were experiencing the most incivility, they found. So lawyers with disabilities at the top, 76. And that's not mental, it's both mental and physical disabilities. And then younger lawyers, early career lawyers, 0 to 9 years out, LGBTQ2S, 72, female, non-white, Indigenous. So that's disturbing. There was also one other major study done in 2023 in Toronto, actually, found the majority of lawyers experience incivility. Over 70, almost 70% said that had been the case. So that's quite alarming. This was the TLA 2023 report. And 30% of that was coming from decision makers, judges, arbitrators, mediators, they found. And they also found equity deserving groups disproportionately impacted. And again, they linked it to burnout, attrition, and reduced diversity. Here's just some quotes from the 2022 study. We treat each other very poorly. I think that about sums it up. But these are voices from the lawyers that took the study. Clients expect it, firms directly or indirectly reward it. Law tolerates and considers normal what else would constitute psychological harassment. So this is not a secret. It's well known in the profession, and it was really highlighted in the study. Now, raising concerns. What if you're on the opposite end of this? So as you saw in the material, maybe the Law Society cannot step in to assist here, whether through guidance, supports, or regulatory action, unless it's brought to their attention. So the question becomes, should you raise it? How do you know when someone who might say to you, I'm just being a fierce advocate for my client, when do you know that that's crossed the line and metastasized into some sort of psychological abuse? And what are the implications in a very small bar like Nunavut? And my main point here is seek guidance. We're going to get into that, and Craig's going to discuss this. And the current law, the case of Groya. So civility was firmly decided upon, you may not know this, by the Supreme Court of Canada back in 2018. So Groya versus Law Society of Upper Canada has had potentially a very chilling impact on raising these issues and having them enforced to their ultimate conclusion. I'm going to leave this up to Craig to discuss, but this was a very important case. But why is this so important? I think this has to matter to everybody. Poor mental health impacts not only the individual making the decisions, but everyone around them. So it also contributes to a poor public misperception of lawyers, extends to our clients, the public, and society at large. It could not be more important. And it's not like the profession has ignored this. So well-being efforts have expanded rapidly. So all the institutional actors have made efforts to try to address this crisis, including law societies across the board. Lawyer assistance programs have come into play. There's been education, mentorship, peer support, pledges, calls to action, individual practices like mindfulness and resilience training. All of this has been going on at the same time, and yet still on the rise. Addictions, burnout, still a crisis, not getting better by any means. It seems to be getting worse by most accounts. And I did it. So we are now over to my friend Craig, 35 years of experience, admin law across provinces, including he's called in Nunavut, prosecution counsel, and very long time supporter and friend of Assist. So I'm really pleased to introduce him to you. Over to you, Craig. Thank you.
Okay. You want to take down the slide?
Yeah,
I don't need my picture there.
Thanks.
Thanks, Bart. Everyone, thank you for being here. I recognize a number of names on the people who are attending, and I know from my own personal experience in dealing with these individuals that they are good examples of civil practitioners, and so I'm glad they're here. I'll talk about Groya, but where does the concept of civility versus incivility come from? And our code of professional conduct, the standard code that the Federation of Law Societies had first propagated a number of years ago, but is pretty much adopted across Canada. And there's three sections that I just want to talk about. First is section 3.2-1, which says a lawyer has a duty to provide courteous, thorough, and prompt service to clients. The quality of service required of a lawyer is the service that is competent, timely, conscientious, diligent, efficient, and civil. So civil is kind of tacked on the end. And so I think it's important, but you can see where that's the first reference in the Code of Professional Conduct. And then sections 5.16, which says a lawyer must be courteous and civil and act in good faith to the tribunal and all persons with whom the lawyer has dealings. And this one's I'll talk about it a bit more because that's what the Groya case was dealing with. And section 7.2-1, a lawyer must be courteous and civil and act in good faith with all persons with whom the lawyer has dealings in the course of his or her practice. So the general outside the hearing room, courtroom. Now, the Groya case, as Mark has already referenced, it had a lot of notoriety, and there's an interesting background to it. So Joseph Groya, a very well-known, respected litigator in Toronto, was defending an individual, and it was in a securities case where, and it comes from the Briex Gold matter. Anyways, very, very long trial. And Mr. Groya repeatedly alleged throughout the hearing that Crown Counsel was guilty of prosecutorial misconduct. And the judge did very little. It really did nothing for the first 57 days before the judge said, enough is enough. The very strong accusations without any substance being put behind them had to end. The Law Society ultimately dealt with that and found that Mr. Groya's conduct did amount to uncivil conduct and that he was guilty of unprofessional conduct. Thanks, Terry, for putting that up. Notably, the tribunal accepted Mr. Groya's statement that he was acting in good faith when he was making these assertions throughout the hearing. And that actually was what the Supreme Court of Canada really hung its hat on when the Supreme Court of Canada overturned the Law Society findings of incivility and unprofessional conduct, and that they found that the tribunal had failed to engage in the analysis of good faith and whether that, because they accepted his assertions, they made an error, a reversible error in the eyes of the court. And the court goes into great discussion about the importance of resolute advocacy and when it can cross the line into zealous advocacy. But that's a very gray line, and it is one that is not easily defined. But what came of this is that what you would think from just reading it, that after 57 days of personal attack and accusations without evidence to support it, that the tribunal could make the inference of a lack of good faith. Now, as I said, they didn't do that. And so that's where it came. But the concern coming out of Groya is that the bar was set very high for what is the crossing over from resolute advocacy to zealous advocacy. And now recognizing it's a criminal case. And so, of course, the jeopardy that the accused faced in that situation and the right to a strong defense and all that is part of the background. But that's where the Supreme Court of Canada has said it's a very high bar to get over to say that it's incivil behavior. And now I'll tell you about a recent experience I had. So I was in the Court of Appeal in Alberta in early April. And one of the issues, of course, we were dealing with, it was a professional conduct issue. But I had made a comment to the bench that, it is rare to see a professional discipline tribunal make specific findings of malicious or bad intent against the investigated person. It's often, it was a mistake, it was misjudgment, it was a poor choice, but it doesn't go that extra mile. And one of the members of the panel was Justice Alice Woolley, who used to be a professor at the Law Society of Calgary, or I'm sorry, at the law school at Calgary, University of Calgary. And she was very quick to agree that, and said that is one of the shortcomings of self-regulation, is that the regulators, the tribunals are slow to make findings of bad intention against regulated professionals. And so for what it's worth, that's the observation that she had. Anyways, it comes back to, well, what are the options available to a lawyer who's facing incivil, discourteous behavior? And I think a little discussion about the neuroscience is going to help here, because what Mark and I have talked about this at length, and if you get into some of the articles and the research on neuroscience, and I'll use the term bullying, aggressive, demeaning, put downs, the express or implied statement of you don't know what you're talking about, you're incompetent. It works. The reason bullies use it is because it works, and you need to understand the neuroscience of the brain. Is that at the basal function of our brain, the amygdala is you are survival mode, and so we were thousands of years ago. You didn't, oh, what was that crack in the bush I hear out there? Your brain was saying, get out of here, get to safety, because if you sat there and thinking too long, the tiger would jump out and eat you, so you were dead. But that's the thing. The brain is fight, flight, freeze, or fawn. And that's why a bully does it. It throws your frontal lobes, your reasoning portion of the brain offline. When the body is being attacked, you go into kind of defense mode, fight, flight, freeze, or fawn. And that's why a bully acts that way. And usually wants you to capitulate or admit or do something. So the thing to understand is that the best thing you can do for yourself is to give yourself space and time. And what I mean by that, and one thing that I've learned and used in the past, is that when the bully says, oh, you don't know what you're talking about, that's not what the law says. And I'll say, you know what, you may be right. I haven't seen that case law. If you can provide me the case law that says what he says it says, I'll review it, and I may reconsider my position if it shows me that I'm wrong. So you give the bully a little a little win in the sense of you're saying, you may be right. I don't know. I want to think about it. So you give yourself space to pull back from that. And you give the opportunity to the bully to show you that they know the law. And most times I've experienced is that they don't have a smoking gun case. And in fact, the case they may be thinking of probably doesn't help them, or maybe even says the opposite of what they say it does. And so that's a good thing. And one thing I also learned, and this is where, as a young lawyer, and I was in chambers, and it was a morning application, and I was given the file by the senior partner, go solve this, get the order, and you get resistance from the judge, right? The applications judge is just not buying what you're trying to sell. And one thing I've learned as a consideration, you ask to stand the matter down, put it at the end of the list, and maybe you make the phone call, or you run to the library and you check on stuff. But it gives you some time. So if the challenge or even the incivility is coming from the bench, you give yourself a little time. Another thing that I found very helpful is let other egos work for you. And there are wonderful free publications. Like Lexology is a daily service that you can sign up for. Supreme Advocacy, Eugene Meehan's group out of Ottawa, and they will send you lots of information on current cases. The articles on Lexology are typically written by lawyers and associates and students, and it's on new and upcoming law. So it's a good way to let them help you stay abreast of things, so you don't feel like you're drinking through a fire hose constantly. And one thing that I was told when I graduated was that in 5 years, half of your class was not going to be in private practice. And that came to be true. And I understand from talking with others that it's still a pretty significant or pretty accurate descriptor, is that half of the graduating class is not in private practice within 5 years. Now, perhaps that's part of the impact of what Mark's already reviewed. The burnout, the displeasure, the unhappiness in being practice. I think of the things that I've heard and have been told to me, litigation is not a cakewalk, toughen up, suck it up, buttercup, all those type of demeaning, dismissive things. And I can tell you that you can be a very effective lawyer and a litigator without being disagreeable. I remember being told very early on, there's cross-examination and there's examining crossly, and they're not the same thing. So there's an article, and I've shared this with Nalini, and she can post it as well, but there's an article that was written by Eugene Meehan, and he presented it to the Law Society of New Brunswick, their midwinter meeting this past February. And it's an article about civility as a tactic. And it contains a great discussion about just different situations you may face and how to respond to it. But it's an example of how you can choose not to dip into the mud and wrestle with the other one. As it has been said to me, and I think it's very true, when you start arguing with a jerk, soon it's hard to determine who is the jerk, because you're stepping into that fray and you're not demeaning. You're getting down to that level, not keeping a higher tone. Another tactic I've used with some success is, be curious. Like when the bully or the aggressive lawyer on the side is, this will fail, that'll fail. You're like, okay, help me understand. Like, you're saying, what facts are you saying are the smoking gun, and what are the cases? So you be curious and let them, tell you. And if they tell you, wow, you'll have to figure it out yourself. Well, then that's probably an indicator that there's more bluff than reality to what's happening. So you've got some things about giving yourself space. And another thing, and this comes from Mark's talk as well, that recognizing when your battery is getting down. And the billable hour, the workload, and the problem is that when you're under stress and you are facing deadlines and all this sort of thing, you're flooding your system with cortisol. It's a stress reaction hormone, and it's there to save us. It keeps us alert. But being hyper vigilant over an extended period of time actually is what leads us into unhealthy behaviors and can lead to depression and lead to substance misuse and addiction. Um, Part of my experience is having grown up with and lived in a house affected by addiction, alcoholism, and how and being the son of a lawyer, I saw it firsthand the profession and how people relaxed or unwound, and the big firm, the lawyers' lounge where the bar was well stocked. And I, as an articling student, that was one of my duties, was to make sure that the bar was well stocked with everything that anyone could possibly imbibe in. And that is a challenge that we have to deal with, is that when we are facing ever increasing demands, and AI is creating more stress for our profession. I attended a CBA session on Tuesday this past week, and it was by the Law Society of Ontario, the CBA there, and it was about AI in the practice. And it was very interesting. There were some very senior lawyers who were on that panel, very experienced in technology, and they recognize that AI is certainly a tool that the legal profession is going to have to adopt, but it is certainly not going to replace us, and it is not going to be part of the team. I saw one commentator say that it's not a tool, it's one of your team members. And I'm thinking, okay, this is HAL 9000 from Space Odyssey. I'm not going to make my virtual team member, but I can certainly use it. And I've tried not to be a Luddite, like, the 35-year plus lawyer who says, it's not important. What's important is between your ears. And that's true, but there was an interesting LinkedIn article by a legal commentator out of the States, and it was about how one of the problems with AI is and they called it misgrounding, in the sense of people they lack the experience to recognize that the output from AI, generative AI, has legal hallucinations or misstatements of law. And so, and the article was interesting because it talked about the growing number of sanction decisions coming out of state legal boards in the US because of the growing number of lawyers who are relying upon generative AI to create final product without vetting it, without looking at it. And I'm sure many of you have already seen it. And the other problem is the stress that's coming in our profession from clients who get the legal opinion from ChatGPT or Claude or whatever generative AI program, and they think they've got a great case. And so their expectations are perhaps higher than they should be. And so that's just another stressor that we have on our profession. And so we are our own worst enemies, in the sense of the billable hour, the expectations to produce and to be the gladiator, and to stuff and not feel, and to be the heartless soul. But I can tell you from personal experience that stuffing down, if you're unhappy or you're not enjoying, or you're feeling less than, stuffing down actually ends up causing bigger problems, because it numbs you down, and the only thing that you'll find is anger. And it'll start coming out in other areas of your life, and people will start asking you that question about, why are you so angry? I'm fine. Of course, the word fine stands for frustrated, irritable, neurotic, and emotional. But that's where, as a profession, we need to have people who stand up. This is a profession that needs that we take care of each other and that we actually treat each other with respect, because we are in a conflict laden profession where we are there to support clients who are going through difficult times. And, if you think that you have to please your client and have to demean and attack the other party or their lawyer, that's where you have to start setting a boundary and you saying, you know what, that's not the way I practice. I will treat the other side with courtesy and respect, even if they are not showing courtesy and respect to me, because that is how I choose to practice. And it may not be what your client wants, and that's okay. But that's probably a client who's going to be unhappy with you because you're not getting into the mud and wrestling, because it costs you more in your own personal health than I think you get any billings from that file. So at the end of the day, what's a good solution? Well, a good solution is you got to look after yourself. Like, what do they tell you on the airplane? When when the masks dropped, put yours on first. Because if you're not taking care of yourself, you become less and less helpful to everybody around you. And that's where we have to make our own mental health and our own well-being a priority. And so I encourage you to look at the paper by Eugene Meehan. It's a good read. One thing I also encourage you to do, and I talked to Nalini about this, is that, if you just want to kind of have a sounding board with a senior lawyer who can just give you, and it's totally confidential. Nalini can put you in touch with a senior lawyer, maybe me, maybe someone else, but just someone to bounce things off of. Um, my role in the assist program in Alberta is being a mentor and a volunteer, but that's what one of the things I do is I'm happy to have a call with another lawyer and talk about the file and maybe give them a perspective they hadn't thought of, and to give them some assurance perhaps that they're on a sound footing, and that maybe just you got bad facts. I had a call like that just yesterday with a lawyer, and so it was. I get a lot of sense of purpose from being able to help younger lawyers and to help others in the profession. I've been the beneficiary of some good support by senior lawyers throughout my profession or my practice. And so I just want to make sure that we have that community of support. And so I hope that something you heard today resonated with you. If you want to have an offline conversation, I'm happy to have that, and happy to answer any questions that anybody may have. So I think we've left a little time here for some Q&A.
Great. Well, thank you so much. Just looking around to see if there are any raised hands with any questions.
And while we're doing that, Rebecca, and if I could just add, thank you so much, Craig. That was amazing. I've never heard that about fine. So he always has some zingers there, and we wrote that one down.
There's another version for the F. You can pick the other version too.
Okay, right. Another thing Craig taught me was Q-tip, which is quit taking it personally, which as I've gotten more into mindfulness, I found that the depersonalization is probably a word wasn't in my vocabulary before, but now seems to be all I think about, because it is a key. And I also wanted to say that in my research, and what was most shocking to me was finding out that we as lawyers might have it backwards. In fact, most of humanity seems to have this one backwards, which is we've been trained and taught as a society and a culture to believe cognition is king. So our thoughts determine everything. Control your thoughts, control your life. Your thoughts create your emotions, create your behavior. But that's not actually how it works. So Craig mentioned neuroscience. So this is called predictive processing. And it's been proven over and over again since at least the 80s, as far back as I can go, that it's actually the opposite. So it's not calm mind, calm body, calm inside, I'm feeling good. It's the reverse. It's calm body, calm mind. So it's a body first approach. And that's just unfortunately, as lawyers, we're trained to ignore the body. I know I did. That's why I developed cancer in 2016, 10 years ago, because I just completely, I felt I could be a brain with a tie on a stand wheeled around and I would be just fine, and this annoying thing that's attached to me that I have to feed and water it's so time wasting. What's the point? But in fact, when you get into it and you start to see how important your physiology is to your mental state and to your actual very reality, because it's the lens of your perception. So your physiology is absolutely paramount. That's why I'm teaching nervous system literacy in law school and finding out sort of what Craig was talking about, how that works, and why we need to pay attention to our inner state, because it is literally what everything is filtered through. So if you're dysregulated and you see everything as a threat, you're going to produce more of that, and it's going to turn that stress and keep it inside your body and turn it into distress. So stress is pure, like Craig said, it's really protective, it's adaptive, it's automatic, it's pre-conscious. You can't control that, but you can control the aftermath. And there are ways and tools that we can teach that and understand so that we don't make it worse for ourselves by keeping the stress going, keeping the alarm going. There's ways you have to shut off that inner alarm once you've been activated and mobilized by stress. So stress isn't the problem. It's our interference with it. That's the key point I wanted to raise here and let everybody know about that. And it's a common, since we're in a profession with the highest stress levels on earth of any occupation, adversarial, conflict laden, hypervigilant, perfectionist, all of those things do erode your mental health unless you are aware of what it's doing to you physically, physiologically, and from a brain perspective. So I just urge everybody to dig into this. We can do more on it later and get into the stress physiology piece, but it's just important to reverse that thinking, to think that your thoughts actually come last in the process. They're not first. And that's a bit disturbing to some people because it kind of dissolves your illusion of control that you think you have over your life. But we just have to understand how we function and know where our leverage is. And the leverage isn't in the thinking. You can't think your way out of a broken leg. It's the same thing. You have to understand how to heal, how to go back to baseline, how to get rid of that automatic stress response that's coursing through your body and taking your cognition offline, as Craig was saying, because that's not a place you want to be in when you're standing in front of a courtroom or in a boardroom, wherever you are. You want you want to be thinking clearly. So that's why breathing and mindfulness and all that stuff, even though I completely thought that was nuts a few years ago, now it is the most important thing in my life to make sure that I'm in the morning starting with the breathing. And it's not just because it's good for you. It's a professional imperative. That's the reframe. It's not just because everybody knows exercising is good for us, but we don't do it. Why? Because lawyers are trained to think rest is weakness, and that is harmful. That's very harmful. You're not a machine. You are a biological organism. It's a rest and recovery system, and you need to honor that and respect that, and then everything gets easier from there. So that's all I wanted to say on that. So Q&A, if anybody's got
And
questions for
it
either
looks
Craig
like
and I.
there are a couple of questions in the chat. So the first one that I see is, are the mental health supports with the ASSIST program accessible in all official languages in Nunavut? I don't know if Nalini might want to chime in on this one with respect to supports and what languages they're available in.
I don't know if John McLean is on today's lunch event.
I see John's hand up. Maybe John can answer that. John?
Can everyone hear me?
Yeah.
Thank you. So yes, hi all. John McLean. You know me from New Lap. Uh, so the short answer is yes and no. English and French, yes, for both psychological counseling and peer volunteering. The roster of volunteers in both Alberta and Nunavut hits both sides. On professional counseling in Inuktitut, maybe we will according to the executive director at Alberta Assist, we could work something out. It would take a day or two, but we could figure something out. And for peer support, please volunteer if you're bilingual or multilingual. We would be always happy to have additional volunteers. The roster is getting a little weak. But then again, I've been a trained peer support volunteer for years and have yet to be called. So so yes and no, but we're always interested in getting our roster of volunteers improved, and we're always looking for ways to improve the professional counseling side of things as well. And we have connections and things we can refer within with other law societies as well. So do not let the language barrier be a barrier to seeking help. We will help you. It just might take some time, but we'll work on it. So thank you very much.
Thanks, John.
Thank you, John. Thank you. There's another question, and the question is there any benefit in raising civility issues with opposing counsel, or is that too confrontational?
Good question, Sasha. I think what I've kind of, if it's a telephone conversation and it's getting heated, I try to take it, says, you know what, let's take a break. Let's just cool down, and we'll continue this discussion later. There are lawyers who I've come to be experienced with that I can't trust them on the phone, because what I say on the phone and what they come back with is two different things. And so and this is unfortunately where you start to develop a list of people who you will only correspond in writing. So it's email or letter, and it's the person who I don't trust, and I'll get the voice message, and so I'll respond by an email promptly saying, got your voice message, thank you, here's my response, blah blah blah. And so I'm setting the boundary, right? So boundaries we set for ourselves. And so if I'm not going to deal with you, and it may be that the person just got a little heated. Like, I had a conversation with a guy, and it was, and I've known this lawyer, and it got a little heated. And I said, okay, here's the background to me. This is why I'm getting elevated. And he said, oh, no, I didn't intend that. That's not what I meant. And so we de-escalated, and you know what, we got on with the conversation and worked it out, and we ended up having a resolution agreement. So it worked out fine. So there's that, but that's conflict resolution, right? So you clarify, what are we disagreeing over? But sometimes I just have to set a boundary where I'm not going to speak to that person over the phone, because I've been what they've said and what they've done otherwise, and I didn't say that, or we didn't have an agreement, right? So the gaslighting that you'll get from somebody who backs away from a verbal commitment, and so. I just have to set it, because it's for my mental health. It's not for them, because I can't change them. So hopefully that helps a bit of an answer.
And thanks, Craig. And if I could add my 2 cents here, just to let people know, there's the slides I used has a couple at the end, including, and it actually, I'm glad someone asked this question, because I have a bullet point on this on the last slide, which you can look at. But I reframe it as, well, it depends is the answer. It depends on how well you know the person. But I reframe raising it with the other lawyer as an act of care, not conflict, because in most cases, if somebody's being completely uncivil and personally attacking other lawyers in open court, etc., I mean, there's something going on there, and that just doesn't come out of nowhere. That person is likely struggling inside and suffering, like so many hundreds of thousands, if not millions, of lawyers have, and that's how they are dealing with it. And like Craig said, you shove and stuff down. Suppression is absolutely the worst thing you can do in a high stress, high pressure environment like law, and it comes out in all kinds of weird ways: projection, anger, violent attacks of other people, and that's what you're seeing. So if you know that person well enough to just go, hey, are you okay? Can I get you some help? Can you what's going on in your life? Kind of, if you can have that kind of conversation, great. If not, then there are other ways that you can you go on our Assist and the Nunavut website about how to help others, and you'll see what you can do in order to offer some. But coming from a place of compassion and care uh, is a way I would hope that people could look at this. And again, it's about the depersonalization. So if you aren't taking things personally, if you can get your ego out of the way and try to not make it about you, but see that it has nothing to do with you, most likely in all cases. The attacks against you by that other lawyer have absolutely nothing to do with you. And that's also a strategic way of handling it, because when you know it's not about you and it's just that other person's going through something, you can just let it bounce off you, and it doesn't take your cognition offline. It doesn't mobilize you and activate you internally, and you stay calm and composed in the face of attack. So that's what I would say about that.
And sometimes, just calling and reaching out to a mentor, sometimes it's just a vent. And I'm okay with that if it's just a question of like, because there's just being a listener, right? And not offering advice unless, and sometimes I found that if I'm talking and getting it off my chest, I may actually give myself the answer of how to solve the problem. And it's just because I verbalized it and I was talking to someone who was not going to judge me, not going to criticize me, not going to say, but you're this, right? So that's what a mentor can do as well. Right? It's just to be a sounding board to let yourself maybe solve your own problem just by getting it out in vocally. So there's lots of different ways we can help.
Looks like we have another question from Sasha Paul.
Oh, hi. Thanks for this. I'm curious about this. I don't want to dominate the chat either, but sorry, I should turn my camera on so you can see how disheveled I am. I think for someone like me who's about 20 years out, my tolerance for people poking me in emails is changing in the sense that I don't want that action to continue on with other people at my firm. And so I've sometimes taken a very firm stand on that, perhaps not as calm and the like as Marcus suggests, but I think I'm curious about the role that older lawyers have in policing civility, both amongst your own colleagues, but also amongst opposing counsel. Because I appreciate that people looking at an old lawyer like me, they don't take as many liberties as they would 10 years ago. And I also appreciate that I have female colleagues who get pushed much harder on things I would never get pushed on at all. So I don't have to deal with that stress. I don't know how you think about the role of older lawyers in the civility context, and then I'll shut up.
Thank you, Sasha. You want to go, Mark?
Okay, I can go first because I've studied this in detail. So thank you so much for this question, because in preparing for my law school course and just trying to crack this nut, why are we seeing all these various symptoms? What can explain it? One of the symptoms we're seeing is that older lawyers are the most uncivil towards others. And so why are older lawyers perpetuating the harm? Shouldn't they know better? Shouldn't they have, learned that that's not the way to be, and that's not helping you personally or others? So it's a lose-lose proposition. But why don't older lawyers know that? So that's the key question. But and my theory, and not a lot of studies have come out and talked about older lawyers perpetuating harm in particular. So you got to read between the lines and make your own conclusions. But if you've been in this business long enough, 20 plus 30 years, without learning some of the things that we're talking about here, and you just are surviving. So you are just waiting till you retire so that you can perhaps have a few days of peace. That's your mentality, that's your inner state, that's your world. You're in survival mode and you are constantly and chronically distressed. that becomes your world, so that's the reality. You know how two people can see the same external, you can have two lawyers in the same office, same practice area, side by side offices, same people around them, and they have two very different experiences of that circumstance. One lawyer is calm, composed, reasonable. The other lawyer is completely uncivil and irrational and flies off the handle at every moment. Well, so why is that? I think most lawyers who are in this long enough tend to, if they've survived that long, they have survived that way using coping mechanisms which aren't the best and which just kind of perpetuate the distress inside their systems. And that's the result that we're seeing. And that's why it's called projection. So an older lawyer who faces a younger lawyer who's taken my course and has set boundaries and know who they are and know the kind of person they want to be. They want to take the high road. The older lawyer will unconsciously, and this is not in a conscious thing, they will try to take that lawyer down and break them and make them as miserable as they are, because misery does love company. And because a younger lawyer who has boundaries represents an entire different way of living, and shows that there was a better way to do this job, and you didn't have to sacrifice all of the kids' birthdays and you could have been there, you could have approached it differently, you could have had some balance, and you could have had a much healthier existence and a much more satisfying, meaningful existence. And so that's an existential sort of threat to an older lawyer, to see a younger lawyer who has that mentality and that kind of boundary setting skills. And so that is a threat. That's my thesis. That's conclusion I've come to as to why older lawyers are that way and why they are so harmful to junior. And this is not across the board. Of course, there are older lawyers that get it and aren't trying to break down junior lawyers, but we are seeing a lot of that. So go ahead, Craig.
Yeah, just the older lawyers, they don't retire, they just lose their appeal. Sorry, bad joke. The success in this profession is often measured in finance, right? So the senior lawyer who has all the billings is the one who is to follow. And unfortunately, I've seen too many senior lawyers who, yes, bill like a machine, but are not good exemplary lawyers who mentor young lawyers, who lead by example, who show civil and professional courtesies to everyone they deal with, be it a self-represented individual, the bench, or members of the law society or the public. And so it is unfortunately part of the billable hour, the pyramid scheme that the traditional partnership of few partners at top profiting off the work of many. And I think AI is an interesting disruptor, and that it's going to be interesting to see how firms that have that traditional pyramid model are going to survive and transform with AI, because AI is offering to remove a number of junior skill sets from humans and put them into an AI program. Someone told me that in professional services for PwC, apparently, the accounting firm has invested $1.5 billion in AI for moving forward. And so, as I said, that article on LinkedIn, misgrounding, the idea of we're losing the skills that are gained through experience. And so we're in a profession that's in a period of transition. And I think we just have to focus on the health of the profession by focusing on the health of individual lawyers. If I can be a positive contributor to the overall profession, that's all I can do, and that's what I strive to do. So is that the mic drop?
Well, we are at the end of our time. I suppose we could accommodate another question, but I mean, it did seem like that was a really strong note to end on. Oh, Nalini.
Yeah, just some final remark, unless someone had another quick question. I don't want to take away from our members' time participation. No, we're good. Okay, I really wanted to thank again Craig for stopping by our office a couple of months ago and having coffee with me. And, I've been in this position for over 15 years, and as a small jurisdiction, there's a different layer of pressure. We've been yelled at. I've been called a few names sometimes, and this conversation is so welcoming, and having like members, like senior members of the bar take the lead and inviting Mark and speaking openly. And I really like the perspective of neuroscience and understanding behavior. Like I would like to be able to dig a little bit deeper with other CLEs, but I cannot thank you enough that, as we feel sometimes remote in Nunavut, and having members and friends of our members join us remotely to have these sensitive, maybe hard conversation, shedding light on I'm sure a lot of us have gone through this. I'm really, really thankful, and I look forward to the next opportunity. So thanks again, Craig, for taking the time to stop by for coffee back then, and finding yourselves today with a nice group of members. And thank you, Rebecca, as well. I know you were just landing in Yellowknife, but I'm glad you were able to kind of take the lead as well.
Well, thank you to Nalini and also to John. This was a real example of community coming forward. And thank you, Craig and Mark. But this is it's a little unusual amongst our CLE, but I'm hoping it's a trend that will continue, that we have this kind of community participation. So thank you so much.